Be cool, be kind, be classy. The cupcake so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are water away. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcake's sweet and sassy. Not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Happy Sunday. Sunday fun day. Today is Sunday, June 14th, 2026. How is everyone doing? How about those Knicks, huh? Wow. Wow. Knicks in 5. That was an amazing game last night. And even though I'm not a basketball fan, I just might be now. I mean, it's Stanley Cup playoffs. So you know that, of course, the Vegas has to win tonight to keep it going. But what a great game. I mean, I wish they could have won at home. So that was a little bit bittersweet. I wish that Mariska Hargitay could have been there because we know how much she loves her Knicks and we know how much I love Mariska Hargitay. Elliot Stabler, aka Christopher Maloney, did post like a video in the street after the game in New York City, and New York City was wild last night. I mean, people in the streets everywhere, people on balconies. It was crazy. The Knicks haven't won since 1973. And it's crazy. I don't think New York City is destroyed. I think some of that was hyperbolic. So I'm not really sure about that. But I did see like a burning bus or something in the New York Post. I don't know. Yeah, why can't we have nice things? Why do people have to destroy things when they're happy? They destroy things when they're mad. I don't get it. But that's sometimes the way it is. What's everybody doing? 1973 was the last time the Knicks won a championship. And so it's a big news in New York. Any New Yorkers in the house? Oh, I just almost dropped my entire phone and everything. Jim Dolan, the Dolan family, the lore of the Dolan family on Long Island. I actually went to high school with one of the Dolan daughters. The Dolans own, back then it was Cablevision. So they owned a local cable company. The Dolans owned the Newsday, which was our local newspaper. They then eventually at one point bought the New York Rangers, the Knicks, Madison Square Garden. They run it all. They own it all. And every summer, they used to have a big, giant 4th of July party at their Long Island estate, which is right on the water. It's on the North Shore. And Billy Joel used to come and play at the Dolans. But the joke is that Jim Dolan, who spoke last night after the win, it's like the first time he's ever been liked. So if you know, you know. Rex Sherman is going to be sentenced this week. It's going to be on Wednesday. He is the confessed Long Island serial killer. And it is going to be Wednesday. There will be a camera in the courtroom, so we're going to be able to cover it live. So that's pretty exciting. It's pretty exciting. But you're not here to listen to all of this. You're here to see Tom Kokonowski. I know you. I know you are. I went back and I just watched the verdict stream where we collectively hysterically ugly cried. I went back and watched it because Tom Kokonowski starting a YouTube channel, and he linked it in a playlist on his channel, which is in the show notes below, by the way. Really, Stephanie? I'm not playing that game. Hold on a second. I was ugly crying. We were all ugly crying. Brian Camp was like our adopted son. But I thought so many of you have been asking for another collab with Tom Kokonowski. He was Brian Camp's defense attorney. So I thought Sunday night would be a great time to do it because you want to know his thoughts on Proctor. You want to know his thoughts on the defamation case by the Haas plaintiffs against Karen Reed and Aidan Carney. And there's so many things that you want to know about. So I thought, bring your questions. Bring your questions. We have a Massachusetts defense attorney here. He's a fan favorite. You know who he is. His name is Tom Kokonowski, and he is the defense attorney who we saw Brian Camp acquitted with. That was a terrible sentence, but in any event, hi, Tom.
Hi, Mel.
How are you?
Good. How are you?
I'm good. I'm happy about the Knicks. I'm not really a basketball fan, but I like to root for the home team, you know?
I'll tell you what, well, first of all, I want to talk about my placement on your intro, which I happened to, like, I always skip through everybody's intro, but I saw that you had a new one. I was not, well, when I was looking at it, it was. And I was not expecting to see myself, but there I was. And how is it, is that Cardi B? Is that her? Did she have a lawsuit?
She did.
And Taylor Swift. How am I before Cardi B and Taylor Swift? I don't know what that is, but
I didn't do it. You know, I'm not very technologically savvy, as we were discussing before in the pre-show while we were trying to figure out our technology. It's Emily C did that. So Emily C, thank you for that intro. She's the one who chose the clips, put it together for me. Love her for it, but can't answer that question. You deserve.
Thank you, Emily C. Although I don't know if I've ever spoken to her. I've seen her.
She's awesome. And she was a kindergarten teacher. So she's very good with visuals and charts and graphs. But for those of us, those in the chat who may not know you, Tom, give them the, the short introduction. What kind of law do you practice? Where do you practice? How can they reach you? You're starting a YouTube channel. We want to know everything. Tell us everything.
You said everything but short? That's how you want
give
it?
us the brief version. We don't have to go from childhood, but like let's talk about well, we can go back to freshman year of college because that's the lore.
I went to the Sergeant Robert R. Litwin grade school in Chicopee. That's too far?
Oh, you did? Yeah. No, yeah. We can talk about the fact that we went to college. We were freshmen at Trinity College at the same time, and we lived in the same dorm, and we didn't know each other. And then I left Trinity like a bat out of hell, and I went to Boulder because I needed to find some hippies because I was a hippie chick, and it was full of really, really rich preppy kids, and that was not my tribe. And you stayed.
Well, they paid, so I stayed. So you must have needed more than hippies because there were 1,600 kids at Trinity College.
Yeah, you would see the same people in the cafeteria every day, and I was like, get me out of here. No shade to Trinity. Listen, a lot of famous people went there, but it just was not for me.
They let me in and made me smart.
You're wicked smart. Wicked smart. But you didn't. Did you grow up in Massachusetts?
I did. Chicopee, Massachusetts, former home of the world's largest kielbasa. When I was there, you were either French or Polish. Yes.
Oh, it's also where the women's prison is, right? Because Kelsey Fitzsimmons was in the women's prison in Chicopee.
Yeah, it's actually not a prison; it's a house of correction. So the prison's in Framingham.
Oh,
that's the big girl prison, and Walpole and Gardner are the big boy prisons. House of Correction in Hampden County for guys is in Ludlow, and Chicopee is a jail for women. Yes. Interesting place.
Interesting. It's kind of far from, I guess, where Kelsey her trial was in Salem.
Yeah.
It was like 2 hours each way.
Yeah. So when I go back out to Western Mass, it's 186 miles, about a 3-hour trip one way. Excuse me. So yes, it's quite a distance. So that's where I was. Childhood, went to Westfield High, was a bomber. Post-grad at the Williston Northampton School, which was one of the most pivotal years of my life. Taught me how to study, taught me how to sort of rearrange priorities. learned there that the coolest kid in the school was also the valedictorian. And I had come from a far different set than that. It was parties, girls, and then maybe academics and sports. At this place, it was like, what? I'm shunned if I don't study. So that's what Williston was. Williston got me to Trinity. Trinity got me to, I went to Western New England School of Law. It's now Western New England University School of Law. And I went to school at night, worked full-time in the district attorney's office for the 4 years that it takes when you go at night, if you do 2 summers, just like the 2 brothers before me did.
Which county were you a district attorney? Or did you work at the district attorney's office?
I worked in Hampden County. I was a victim witness advocate. I know that you guys have heard that phrase before.
Mm-hmm.
As have I. I was a victim witness advocate. I was lucky because they knew I was going to law school at night, and they basically trained me by having me be the homicide unit victim witness advocate, which was rewarding in so many ways. Very sad in many ways, having to deal directly with victims of homicide and be the liaison between the prosecutor and the family, but taught me a lot of stuff because I was always with the best lawyers, trial lawyers doing murders, and learned a lot from watching them and working with them. Became I was a student prosecutor for a full year. Tried 20 or 30 cases as a student. Got my rear end handed to me for the first 10 trials I did. I lost 10 trials in a row.
That's how you learn.
And then the first trial that I won, for anybody who plays baseball, it was like hitting a baseball in the sweet spot of the bat. Like you don't even feel it, and it's a home run. The problem for me was, though, as I was getting better, I was approaching the day that I was going to have to put somebody in jail, at which point I went to the district attorney and said, I gotta go.
Interesting.
And so I'm much better suited on this side of the law.
Just trying to ensure that people receive a fair trial despite guilt or innocence.
Because for many different types of things, not all things, in my experience, there but for the grace of God, go I. Right. And so I got out of a lot of different things, not having to get all the way into the courtroom, but don't know how I avoided it, but I did. And so I don't judge anyone in that regard.
So your entire career as an attorney has been as a criminal defense attorney. You never worked on the prosecution side. Oh, you just froze up at me. What was that I told you about the Ethernet? I'll just wait until he unfreezes. Okay, you're back.
Yeah, I know this is all my stuff because it's brand new and I didn't download it.
Listen, you're down the Cape, right? I mean, it's like spotty service. It's like being out on Block Island. There's like no internet. It's like crazy. We're gonna get you set up though before you start doing your own YouTube channel. We're gonna get you there to the.
Yeah, the lighting. I look.
No, you look good. The lighting is good. It was better. Remember before we adjusted it a little bit.
Yes.
You can turn it down. And don't you have like the light do you have like a high and low?
Yeah, it's all the way. It's all the way over there, and I'm not moving.
Oh, okay.
I'm not moving in case I jostle something, and then I'm gone forever instead of frozen.
Maybe you could teach George Clooney how to work lights.
I expect George Clooney will probably be in here because I tried to make this quote unquote studio also a closet, my place, so there's no cat hair on my suits and that kind of stuff. But when I close the door, when I close the door and I don't let them in, there's just incessant meowing to the point where a judge said the other day on a Zoom hearing, "Will you let George in?"
The judges know George?
Oh yes, yeah. The judges know George mostly from COVID when we were doing hearings.
For those of you who don't know, George Clooney is Tom's tuxedo cat, who often will come and sit on Tom's shoulder while he's with us. So you never worked on the prosecution side, except when you were a student? After you passed the bar, you were always a defense attorney?
No, I became an assistant DA for about a year and a half, and you know, I worked in Holyoke, and just told all the other prosecutors, most of whom were happy with me, saying, I want every trial. Give me every trial that there is. And in Holyoke, there's some pretty serious stuff that goes on. So I got a lot of good experience, but I'm not wired to put people in jail.
So you always wanted to be a trial lawyer, just like I did. I think that's because we both are also frustrated actors. We were comparing period costumes the other day. I was going to make a side by side of us, and now we're like,
I was praying you would.
Costume. You want me to? I can try and cobble it together, but hilarious.
That would be. I was expecting that. That would have been a good one. Maybe next time.
I could probably whip it up while you're talking about something else, but.
me and my top hat.
That's hilarious. I know. I played the wife of the inventor of Coca-Cola in the TV series The Food That Built America. And Coca-Cola had cocaine in it. And apparently somebody bought it for like $200 and I was left penniless. It was tragedy, but it was so much fun shooting that in period costumes and, in a cemetery. It was a lot of fun. And you were on stage in your costume. That was Scrooge, or that was something else? You froze again. We're gonna fix it. Don't worry. Do.
Could you see me during that?
No, not at all. You're frozen now. You're unfrozen.
I was nephew Fred in A Christmas Carol. It's one of two characters where I was the good guy. I'm always the bad guy on stage. But he was like, nephew Fred is the nicest guy that ever lived, ever. Juxtaposed across the stage, upstage, downstage from his uncle, Scrooge.
And now you are a very high profile criminal defense attorney with offices. You practice all over Massachusetts. I know you have an office down the Cape in Barnstable County. And I know you have another office in where? In Hamden or Hampshire?
So my original office out here is in Orleans, and I recently opened an office in Barnstable, which is kind of the big city part of Cape Cod, if there is such a thing. And I still have an office in Springfield. I'll go back to Springfield for repeat clients, bigger, clients, bigger cases that actually pay, which are few and far between, bigger cases. So yeah, I still have a presence out there, but the drive has been too much, and so I'm driving less and less out there, and it's starting to settle in sort of permanently full time here, which is good.
Nice place to live if you can handle the traffic in the summer, or you just don't leave.
You learn the patterns, and I never schedule anything on the other side of the bridge on Fridays because coming back is a nightmare, and Monday mornings are a nightmare leaving. So Monday mornings are left open for new cases on the Cape.
We hypothesize that that's the reason that Judge Cannoni during the Karen Reed trials would have only half days on Fridays so that you could miss the traffic getting onto the bridge to the Cape.
Probably through experience. Yeah, it is really, really something. You want to practice patience. What does the bumper sticker say down here? I don't have it because I don't need any confrontation. I get plenty of that in my job, but I'm not on your vacation.
Oh, that's fun. I like that. Oh, that's hilarious. I need that. So it was the Brian Camp trial, the first trial that, skyrocketed you to the fame of being on Court TV as not as a guest, but as a trial that was being covered on Court TV.
Yeah, I was. I don't think I put it in my intro video.
Damn freeze. He's freeze. You're frozen again. At least it's a good freeze. At least when you do freeze, it's a good freeze frame. Sometimes I get a really ugly freeze frame. Oh, wait. You're back.
I am.
Okay, so quick, before you freeze again. That was the first time. Set us up with the Brian Camp, just like a little bit of the facts of the case, And then I want to play the verdict because so many people in the chat here watched the verdict with us together because it was fascinating and we loved your Mad Men style suits. That was one of the big things that we really, your sartorial splendor was something that really we were rooting for the whole entire time.
Brian Camp was a 22-year-old guy who had a biological child with his girlfriend and was a stepdad pretty much to her other child. And at about 12:30 a.m. The day after Christmas, he was sound asleep in his bed upstairs. His girlfriend was kind of awake, heard a noise, turned around the corner, saw somebody coming up the stairs. Guy came into the room, jumped on top of Brian Camp and started choking him to death.
So it was a home invasion.
Yep. Turns out that the guy who broke in wound up having a knife and handcuffs. Brian fought him for something like 19 or so minutes.
Yeah.
His girlfriend was on 911. She ran out of the room. She actually hit him, the intruder, over the head and split him open. And that caused a lot of the bleeding that you saw in the trial, the pictures of the other guy's blood all over Brian. Brian begged him to leave, and the guy would not leave. He was there to kill somebody, if not everybody. And
yeah.
Go ahead.
No, you keep going.
Brian decided to get him. The kids were upstairs, and his number one thought was get this guy away from the kids. So he ran back downstairs as bait to take him away from the two little girls who were, who knows when they were awoken, but they were in there.
And where did they live? What town?
It was Chesterfield.
Right. And so that was Hampshire County, right? And it took 20 minutes for law enforcement to get there. And I listened in preparation for this today. Well, I listened again to the 911 call, and it still haunts me. Brooks 911 call still to this day haunts me. And this trial was kept so under the radar. None of the media was covering it. I remember we didn't even discover the trial until I think you picked a jury on Monday. By the time we discovered it, it was Thursday. I could only cobble together bits and pieces of the testimony and bits and pieces of openings and closings. And I just want to take us back now to those of you who watched it, remember how terrible the court TV coverage was? It was an abomination. It's no wonder they're gone. But this is me. I hate me watching me, but sometimes we have to do it because this is when we were waiting for the verdict. They're letting Big Case Mike stay on? Yeah, Big Case Mike was on that day. He was the worst, that guy.
A lot of things.
Is that the guy with the pink glasses?
Yeah, could have done.
No, he was the one who hated Karen Reed. He's like, I hate that woman. He looks like the devil, kind of. Mike, come on. Okay, who's the prosecutor here? What's his name again?
Steve Gagne.
Gagne, okay. This is what they were saying what Brian Camp should have done. They charged Brian Camp with manslaughter because Brian Camp shot Jonathan Latender, a home intruder, once. He was still alive. And then 8 minutes later, he shot him a second time, and that's what killed him. And Hampshire County DA made the determination to charge Brian Camp with manslaughter, saying the first shot was good, the second shot was not good.
I would like to correct you to make it clear.
Yeah, okay, good. Because this is what Court TV reported.
Murder was presented to a grand jury. The grand jury decided no murder. The grand jury decided manslaughter.
Wow.
So we thank the grand jury actually in that situation.
And he was facing up to 20 years, right?
Correct.
Okay. This is the terrible court TV coverage, and then we're going to watch the verdict.
That Brian Camp could have done in those 8 minutes and 43 seconds. Those 8 minutes and 43 seconds were full of decision points for Mr. Camp.
Yeah.
He could have stood
after getting the crap kicked out of him for 15 minutes.
Right. Right. And remember all the guns that were used, and there was like a rickety musket to steal that from Kathy, gossip rumor and innuendo. There was like a rickety musket. Like Brian Camp was trying to get away from this guy. She called him pocket-sized Brian Camp because, I mean, Jonathan Latender was like twice his size, right?
Jonathan Latender was my size, and Brian Camp was 5'8", 140. I'm 6'2", 229 today.
I mean, and he was on the kitchen floor. And then I remember the 911 operator telling Brooke to tell Brian to go back in the house and check on Jonathan Latender's condition.
That's what I really stressed that, because he had no intention of going back in there, and the dispatcher, because where are the effing police? There were two ambulances that were quote unquote staged very close by, but they don't go in, they stay staged until law enforcement gets there. Law enforcement was not there. And so the dispatcher is asking what the guy's condition.
Damn. Oh, damn. I'm going to turn your mic up. Is Tom low? Is that what you guys are saying? I'm going to turn Tom up a little bit. And then when he comes back, hopefully it'll be better. Okay, let's see. Talk now.
She asked him to go in and check on his condition. And you could hear Brian say a couple of times, "I don't effing know and I don't effing care." And he went at the request of essentially law enforcement, went back in, and that's where the other guy was getting up.
Right, and would have come after him again. And he had no choice but to defend himself. And they chose to prosecute Brian Camp because Jonathan Latender was no longer among the living. And then this guy Gagne, in his closing argument, made some wild suggestions of what Brian Camp should have done instead of protecting his family. And that's the point that we're up to right here in the video.
He could have stood guard.
Let me see if I can boost this. Hold on. It's always volume. Oh, there's always volume issues.
Over Mr. Latender.
That's louder.
Over Mr. Latender. He could have put his foot on his neck. He could have kicked him in the head. He could have gotten his girls out of the house.
We're in real time, Scott, so there better not be any spoilers.
All the weapons in the kitchen within reach of
We're like 1 second behind.
He had so many options.
Come on, man.
Deadly force.
3 seconds. How do I get on real time? They were 4 hours out for 4 hours.
Right, we're going to take you into live court. The jury is coming into the courtroom so we can hear the verdict together.
I have a request.
Do you like watching yourself or do you hate watching yourself?
No, I hate watching myself.
Okay, well, it's mostly the back of your head. But for those of you who don't know about the Brian Camp case, I think I linked the entire playlist below of my coverage on it. And this is Brian Camp.
But that's not my request.
What's
my
that?
request is that we listen to the knuckleheads on Court TV.
Oh, yeah.
After the verdict, please.
You got it. We're not really going to get to see you much, sadly, but you're right here so we can see you.
A nice suit.
I'm holding my breath. Literally holding my breath. Every second felt like an hour long, I bet, for you.
Yes. There needs to be a class in law school on how to deal with this gap in time right here.
Pardon, may I inquire?
You may inquire.
Thank you. What say you, Madam Foreperson, as the jury agreed upon its verdict in Hampshire County Indictment 2380 CR 0032 Commonwealth versus Brian Camp?
Not guilty.
Not guilty!
You have agreed upon your verdict? Yeah, that's okay. If you could please give the verdict up to the court officer.
That was so crazy. She was supposed to say yes or no. Have you reached a verdict, right? She was supposed to say yes or no. And instead she's like, not guilty. Not guilty.
I thank her for shortening that period of time. Thank you very much, Madam Foreperson.
I know. I think in law school they should have like some sort of like, breathing class or something so that you can, what to do with your jitters, because they don't teach you that in law school.
I never, and I don't ever look at the jury when they're coming back. You can't tell anything from what they're doing.
Can't. And you can't tell based on how long they're out, right? You never know. A short verdict, and they were out for over 4 hours, as I recall, right?
Yep.
A little over 4 hours. Oh, man, that was a long day. What time? Do you remember what time the verdict came in?
It was near the end of the day. It was, I think it was 4. I think they went in for lunch. They went in to deliberate around lunch.
Yeah. Our faith has been restored in humanity. Our faith has been restored in Massachusetts. Brian Camp, not guilty. She didn't even, the foreman didn't even wait. The foreman was like, just like,
What say you, Madam Foreperson? As to count one of Hampshire County indictment charging the defendant Brian Camp with manslaughter, is he not guilty or guilty as charged?
Not guilty.
Members of the jury, hearken to your verdict as the court will record it. Upon your oath, you do say that the defendant Brian Camp is not guilty. This is a unanimous verdict of the jury. So say you, Madam Foreperson?
I do.
So say you, all members of the jury.
Yes.
Thank you.
All right, ladies and gentlemen, I want to thank you. I'm going to have you step back out to the jury room. I do want to come back and personally thank all of you for your service here today. It was with great thanks that we, on behalf of the community, thank you for your service in this matter, and I'll be back to see you in the.
how do you pronounce this judge's name?
Menitsis.
Menitsis. I mean, this was November of 2024, right? This was like right before Thanksgiving
Yes.
is when this verdict came down. And
Yes.
it was right after Karen Reed's first trial. So it was, she had had a mistrial. Our faith in Massachusetts had been just decimated.
Yes.
And then we stumbled upon this trial and you restored many of our
Well,
faith in the Commonwealth.
And it took us 5 days and 4 hours to get it done one time. Thank you very much.
I know. Thank you for that. It still makes me cry watching this. Let's listen to these idiots on Court TV and what they said after this, because they couldn't believe the jury found him not guilty. It was wild.
This is I try not to revel in people backpedaling, but when you're talking about robots, you don't know what to say.
Let's listen.
To the jurors in just a moment. Thank you.
Oh my God. And Bo is
Her
there.
mouth is hanging open, not guilty at manslaughter. I respect
Her mouth was hanging open. Could you imagine? Her mouth is hanging open. She's a judge. Really? Okay.
the jury and the decision. But Michael and Josh, I am surprised again because of the 8 minutes. Even though he testified in his own defense and described why it was self-defense, I thought for sure this jury was going to say guilty based on the evidence presented. Michael, you first.
Biatch.
Judge, actually, I always use the analogy of if the jury was a jury of robots versus a jury of human beings. A jury of robots would have convicted this man. In the first year of law school, in the
I hate this man so much I can't even listen to.
Really?
You see my reaction.
A jury
that
of
was Big Case Mike. That was the guy called Big Case Mike.
Jury of robots is what you can come up with. If you're teaching about juries of robots in law school, people should get some money back, because it may be happening in the future with what's going on here, but I'm not sure I've seen a manslaughter trial tried in front of robots. Anyway, go ahead.
I know, this makes me mad.
Let's
just rejoice. Let's just rejoice and give praise to the Lord our God. The Commonwealth of Massachusetts has finally been saved, and Brian Camp is not guilty. Not guilty. Massachusetts, you've redeemed yourself for now. Now, step the duck up, and let's dismiss the cases against the charges against Karen Reed. Wow, 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 wow. And our friend Bo Bo's in the chat today. She was on Boots on the Ground. I don't know if she introduced her to herself, to you, but she was talking to Brian while the verdict came in the hallway, playing.
I'm like, I found that out, and I'm like, you little shit! I told you don't talk to anybody, but that's.
I don't think she was really talking to him. I think she was more talking to Brian.
That's
trying to keep her calm.
That's Brian. He's a good
At
guy.
the courthouse, aka Adam Lally's resignation, aka our girl in court, had a long conversation with Brian, and had Brian watching Kathy's gossip rumor and innuendo feed to keep him busy while he was waiting for this this verdict. And praise be. All I can say is praise be. Not guilty. Are they still ducking talking, or are they going to let us hear what's happening in the courtroom and let us maybe
was acquitted of this, and so
see, we finally got to see your profile here. Okay, and here's Big Case Mike again. This is the guy I'm talking about. Listen.
Okay, big
Talking,
case.
talking, or are they going to let us hear what's happening in the courtroom and let us maybe?
Was acquitted of this, and so
I'm sorry. Big Case Mike is not for me. Not for me at all. There's a nice moment between him and his attorney.
Aw,
I mean, are any of these local stations going to maybe get a courthouse interview? Do you think? I've never really admit this. Like the jury was out for over 4 hours. Magnolia Gypsy, over 4. Oh, is our friend Bo there? Wait, let's see. Looks like maybe some of the friends and family. There's not a lot of people in that courtroom. It's not, and there's also not a lot of seats there. He should get his gun rights back now. Yeah.
There he is.
No, this guy is Mike Josh Schiffer.
Oh, he's the robot guy.
Different, but he's got no. That was robot guy Mike Schiffer. I mean Mike Jafar. This is Josh Schiffer.
Oh
yes. Oh yes. Have all adopted Brian Camp as our son. Did a win, Susie Costello. Brooke is there, taking on court seat. Case Mike, he looks like the devil. I'm sorry, but he looks like the devil. That's the guy. That's the guy who talked about the. Oh, there's Big Case Mike. He looks like the devil. I'm sorry, but he looks like the devil. He really does. I can't believe that they are so narcissistic that we yacht today, Satan. They think that we care what they have to say about this and that we don't want to see what's going on inside the courtroom. Wow. Yeah, and that's why Court TV is no more. You know, they're gone, right? I think I spoke over the commentary because I got so mad about it. But if you want to refresh everyone's recollection about what they said in their commentary that made you so mad, please do.
It didn't. I mean, it didn't make me mad. It was, I to sort of go back to your first question about high-profile cases. I've been doing this for so long. High profile for me used to be when I was a young man. I remember the highest profile case a long time ago was 2 police officers accused of stealing money from Mexican tobacco workers, and I represented one of the police officers in the trial, and that was huge. But back then, huge was top of the fold, above the fold in the newspaper, and one of the 2 local stations was there. That was high profile.
Mm-hmm.
And I've had, I just remember I saw that there were cameras and stuff, but I'm in a bubble. It's kind of an escape. Like, it's a different world, especially that case. And I saw the cameras and, I was like, whatever. And then when it was over and I was home and I started getting, actually I got phone calls in the hallway as I was leaving from lawyers who were watching. Which was pretty amazing. But I started watching this stuff, and I was just, okay. I mean, I guess that's how you make your living, but when was the last time you tried a manslaughter? Not to robots, sir.
Right. Most of the people that they have on to talk about the cases really don't even do any due diligence or any research on them. They're just spewing stuff, and you don't get paid to be on Court TV. It's like a joke.
The 2 most important questions I asked every juror, speaking of non-robots, I asked every juror, man and woman, have you ever been in a fist fight before? Because you don't know how exhausting it is to be in a fist fight and throw punches for a minute, let alone 20.
Right.
And if you watch hockey, because the guys who fight for a living don't fight for more than 40 seconds because they're exhausted at the end of it. This was 15, 16 minutes of getting smashed over the head. And I wanted people on that jury who understood what Brian was going through in those minutes and where it left him when he was told to go back in and check on this guy's condition. So no.
Outrageous.
No robots, sir.
So you wanted people who had been in a fist fight. So.
Absolutely.
Right.
I think it was Mike Tyson that said everybody's got a plan until they get punched in the face.
Oh,
that's true.
That's a good one. That could be our motivational quote of the day. Everyone's got a plan until they get punched in the face. Mike Tyson.
Well,
There it is. You heard it here first, folks.
Yes, but we don't choose violence. Go ahead.
No, we don't. But did you get to speak to any of the jurors after the trial?
No.
Oh, okay. Sometimes they like to talk. I find that to be the most insightful thing that a lawyer can do is if they're willing to talk. Especially if you lose, by the way. Especially if you lose, talking to the jury is invaluable.
Yeah, we can't approach them. They can approach us. If I want to try to be approached, we'll hang out by the door, make myself available in case anybody wants to say anything. My first ever jury trial, a juror came by, and as she was walking out, because I was a prosecutor and the guy was found not guilty, she was not happy with me. She came up to me and she said, 2 things, young man. You were too mean when you were cross-examining him, and you gotta buy new shoes.
Wait, this is when you were an ADA or when you were a defense attorney?
No, when I was a prosecutor. My first jury trial when I was a prosecutor in Holyoke.
They look at your shoes.
Oh.
See? And after that, then you started getting custom suits and really expensive shoes. I'll just keep talking until you unfreeze. Don't worry, it's fine. The things that jurors pay attention to, right? All right, you're back.
That's it's everything. Because
And I bet after that you never wore like unshined shoes again.
I went without food so that I could have new shoes.
Look at that. Now you have to keep George Clooney away from your suits.
Because
you cannot be walking into court with cat hair on your suit. I'm sorry. It's just not a good look.
Liam, my cat Liam, who's a big boy, I found that one of my suit pockets was torn because Liam likes to reach up in my closet and do this to myself. Yes.
Keep the cats out of there.
Yes.
I had a question and then I just lost it.
About
you have you have teased in your new trailer for your new YouTube channel that you will be interviewing Brian Camp on your channel. So that's exciting. So everyone should go sub up to Tom's channel. The link is down below. It's called The Court Steps. And
actually,
I guess it's going to be your first interview.
So I meant to start with this, but everybody's got a plan till they're punched in the face.
I'm sorry I punched you because I have like
virtual.
Look, something so shiny.
Virtual punching. So I put, I forget where, either in the description, because I'm still trying to, I am the Great Oz behind this curtain. I am a goofy, stumbling. I'm just like, what is going on? Anyway, so I said, give me some suggestions, and your people.
My people, the cupcakes, Tom, the cupcakes.
The cupcakes, some of whom have subbed to me, are not shy about giving suggestions.
Yeah.
And so one of them was, I tried to find you and your name is nowhere on the title, so you should put your name on it. I'm like, you know what? That's a good idea. So the actual full name now I'm wondering if it's too much, and I'm sure I'm going to get comments from somebody one way or the other. On the Court Steps with Tom Kokonowski.
There you go.
Because that's what you're going to be. The Court Steps, as my client's mother pointed out to me, reminded me.
Tell us the lore. Tell us the origin story for those who have not had a chance to watch your video yet.
The origin story of that was from an email from a former client of mine. And I don't know if I made it up or not, probably not, but my experience is everybody hates a criminal defense attorney until they're kidney.
I use that quote all the time. I stole that from you. He's frozen again, but he said, if everybody hates a criminal defense attorney until your kid needs one, truer words have never been spoken. You're up to 778 subs, so we're going to keep it going. And Mitchell says I'm subbing to George Clooney. All right, you're back. It was serious stuff. What kind of case?
It was drug distribution, and young kid, and
was it cocaine?
No.
Was Michael Proctor involved in the investigation? Because he has admitted in text messages, we're going to get to this, that he might shove a nightstick up a guy's butt, plant a bag of Coke on him, and say, "You're going in." So if Michael Proctor was involved, you have a good chance of, I don't know, maybe a civil. You probably got the guy off, but a lot of people might be banging down the doors. We'll talk about
Hang
that.
on, I have whiplash from that quick turn right there.
You have to be ready to go, Tom. We have a lot of side conversations.
How long has it been? How long has it been since I've been on here? Year?
I don't know. I didn't look
More
it up.
than a year? Yeah.
Maybe.
So
not that we don't talk off
right
line, but you're just too busy for me. You're too busy to come on here.
I have to watch you. That's the only thing I can do is watch you and hope that I can float a message up. And now that it's not my name anymore,
are you too cheap to super chat?
Nobody recognizes that it's me because it's court steps and people.
Oh,
no idea.
All right. No.
I'm going to change it to George Clooney. So we got this. I got an email from his mom, and his mom said in her email, and the case had been resolved. I can tell you exactly 2 years to the day that she sent me the email, because the email said, "I just want to tell you that I'm sending this email of gratitude because her son that day was celebrating his 2nd year of sobriety."
Oh, wow.
And she described how helpful I was with the stressful stuff in the courtroom, but she also stressed what we did on the court steps. And what I do on the court steps is, if a client is interested in hearing my experience with all the different things that happened to me and stuff that I did, that, as I said, I don't judge anybody, because there but for the grace of God could have gone I talk about it, and hope to show them that even though they're in this spot right now, it can be changed around and you can do good things. That's a generalized, each client is different. And so I did that every time, and every time he stood and listened and asked questions, and that email got to me, man. That one was. Sometimes we defense attorneys do good stuff that's not in the courtroom, but is out on the court steps. So that's why I named it initially the court steps. Now it's on the court steps with Tom Kokonowski.
So you helped the kid turn his life around, and his mom thanked you 2 years later, and that feels good, doesn't it?
I shared my experience with him. I shared stuff that I did to make myself better. He changed his own life.
Right.
It sounds like maybe he took some of my experiences and made them his own.
Hello. It's paying me $5 to see if you can turn your mic up. I think we fixed it. Right? Is it better now? Is it better now? And then paid me another $5 to say, why was my comment but deleted? I don't know, because you want to hear what Tom's saying. So can you hear him now? Is that
good?
Can
you hear me now? If I get closer like this?
Well, I turned it up on my end. Thank you. Hello. And on top, thank you for your super sticker.
Yeah, this is, by the way, as I'm jumping into this, whatever it is, this is my fault, not Melanie's fault. I got different equipment.
But like you said, people, all right, I'm gonna try and just be nice. See, and then it distracts me, and then I forget what I'm talking about. That's why they call lawyers counselors, because you're not just a defender of people or a person who you're counseling them as well. Lawyers also are called counselors. And so,
well, many times, most of the time, stuff that I'm dealing with, people have outside the courtroom issues.
Right.
Is it alcohol? Is it drugs? Is it mental health? Is it all of it? Are you going to do something about it so that we're not back here again and you're paying me stupid money because you did this again? Or are you going to take some suggestions? Are you going to try to get help and stop being the victim of the world? Because, self-pity can be a pretty comfortable place, but it gets me absolutely nowhere, as I learned.
Mm-hmm. Well, you did, or you did. I mean, handle a lot of DUI cases. I remember your website at one point was like DUI lawyer in Cape Cod or something. So I wonder, because I think a lot of people wonder, what should I do if I get pulled over? What should I do if I get pulled over and I see the berries and cherries behind me and I get pulled over? Maybe I had a drink or two, or someone in the chat might have had a drink or two. What should you do? Tell people, give them a little bit of free advice. God forbid they ever get pulled over, they really will call you and get in trouble. But what's your advice on that?
My first piece of advice is don't drink and drive.
100%.
But as I used to put on the back of my business cards, but if you have, here's what I would do.
Oh, that's a great idea. You put it on your business card. Good. Tell us everything.
So it depends. I can tell you that, blood alcohol content, the quote unquote legal limit in Massachusetts is 0.08% for people over 21 years old. That's not a lot. It's not a lot of alcohol. It's not a lot of alcohol if you've had nothing to eat. Beer is alcohol, just like vodka is alcohol, and many people make the mistake of, I've only had 2. That might be too much for you. So, there's administrative penalties that you have to take into consideration, and then there's the criminal penalties that you take into consideration. So if you've made the mistake, you're going to be told, you're going to be asked by the police officer, where are you coming from and where are you going to, and have you had anything to drink tonight? Of course, we have the Fifth Amendment right not to say anything that might incriminate us, but most people do. Most people admit. The good news is that the jury instruction to the jury about being under the influence says it's not a crime to drink alcohol and drive a motor vehicle. It's a crime to drive a motor vehicle after drinking so much alcohol that your ability to operate it is impaired, to operate it safely. So depends from person to person. So you have they ask you to do field sobriety tests. You don't have to do field sobriety tests. The 9-step walk and turn, the 1-leg stand, and the alphabet are the standardized ones. You don't have to do it. You
can just refuse.
You can just refuse. That can't be used against you in a trial.
Listen, did you see Tiger Woods' recent DUI stop? And he did all the testing, and he's had how many leg surgeries? He could have just refused.
Correct. Well, I don't know. What state is he in?
That Florida.
Yeah. So this is Massachusetts law.
Okay.
Massachusetts, they can't even say the words field sobriety test in your trial if you refuse them.
Really? So it would never come into trial. So the best thing would be just to say, no, I'm not doing that. I also saw Mary Lou Retton do it. Remember Mary Lou Retton, the gold medalist from the Olympics? She used to walk the balance beam for a living. It was not pretty. It was not pretty. Her walking that line, she couldn't do it at all.
And there's a difference between I can't do them and I refuse to do them. I can't do them comes into evidence.
Oh, good to know. Listen, pro tip, Massachusetts residents. Well, he froze again, but he said, I can't do them. Don't say that. Don't say I can't. Just say I refuse. The magic words are I refuse.
There's a breathalyzer that they'll offer at the scene, which is the preliminary breath test. That cannot be used at trial no matter what you blow. That is used to establish probable cause. So they don't have to tell you what the reading is. Sometimes they do. But if they smell alcohol, bloodshot, glassy eyes, if they've stopped you for whatever, swerving or weaving and all that good stuff, if they have probable cause, they'll arrest you, and then they will bring you to the barracks or the station where the big boy breathalyzer lives. And they're going to ask you booking questions. These days, everything is video and audio recorded. State police were the last to the party with body-worn cams, but they, of course, now have everything.
Well, that's
And
funny because Michael Proctor didn't have that back in 2022. So is that new? The body cam for the MSP? Or do they only use it for drunk driving stops?
no, they have it pretty much anytime you go out. Yeah, they had it. Brian Camp certainly had it in 2024. We saw that video.
Yeah.
So then the big decision happens at the station with regard to the breathalyzer. If you refuse the breathalyzer and you're over 21 years old, you are going to have a 180-day license suspension. But I'm likely to win that case if there's no field sobriety test and no breathalyzer. If you take it and fail, you have a 30-day loss of license. But if you have 0.08 or higher, the jury instruction is pretty harsh. It's basically, if you believe it was properly given and you believe the machine and this person had blood alcohol content of 0.08 or higher, got to find them guilty. And you're actually charged alternatively, either OUI or blood alcohol level of 0.08 or higher. So, a lot of my clients need their license now. And so, bricklayers and people who have to drive for a living and don't have the extra money to pay for whatever, and they need to get to the job site quickly, and doesn't matter that they have an OUI on their record and that kind of stuff, then there's a standard first offense disposition, and then there's more of a suspension of your license and stuff. Other people can't have any sort of admission or conviction.
Nope. He's gone again. Okay, you're back.
Those are all the alternatives, starting with don't drink and drive.
Yeah, no, horrible choice always. But I would just always, in New York, it's a 1-year automatic suspension of your license if you refuse. So in Massachusetts, they're saying it's only 6 months. So I guess the play would be you can refuse the roadside test. The only reason they use the roadside test is to get probable cause to bring you in, but they can always find probable cause anyway. And then by the time you get back to the barracks, then some time has passed, and that's when you take the big one, I guess.
Yeah, probable cause is smell of alcohol, bloodshot, glassy eyes, slurred speech, whatever. If you were swerving or weaving or crossing lines or whatever, admitting to a couple of beers, that's probable cause you're going to get arrested.
Yeah. Why does everybody? Oh, yeah. I only had one. I only had two. What's the following the pen test? What is that supposed to be?
That's called the horizontal gaze nystagmus test. That is also used to establish probable cause because it is not admissible in trial fully. Most judges don't allow the whole thing in. I have a trial coming up where the prosecutor is looking to admit some portion of it, and there are some judges that let some portion of it in. But for a quick explanation as to what the horizontal gaze nystagmus test is, here's your eyeball. Here's the muscle around the eyeball that squeezes onto the eyeball tight.
Don't do that. People are going to clip that.
And
okay.
moves it back and forth. The muscle moves it back and forth smoothly. When you have alcohol in your system, that muscle opens up and your eye jiggles as you're following the pen. And then they hold it out at 45 degrees and your eye twitches as you're looking at it.
Oh.
But that also is in head injury people and can be caused by other stuff too.
And some people, they tell you just move your eyes. If you move your whole head, then I guess that's a tell too, because you can't follow directions.
Yeah, it's a following directions under those circumstances is kind of there's definitely, especially with all the body worn camera, following directions with tractor trailer trucks whizzing by. And this is the first time you've ever had contact with a giant state trooper with guns and muscles and his hat on and his authoritative way he's speaking. And now you're being asked to stand on one leg for 30 seconds and you raise your leg too soon. Come on.
And I mean, this is a good place to pivot, a potential Massachusetts State Police trooper's potential bias, which we are now learning about in all of Michael Proctor's newly released text messages and voice memos and all of the things that have been discovered in Michael Proctor's 12 years, contents of his personal phone, and some of the messages and group messages and voice memos that have come out are pretty horrific. Have you had a chance to see any of that stuff?
Unfortunately, yes.
Give us your thoughts. I mean, this guy is clearly a virulent bigot who said some pretty horrific things about black and brown people, women. He's an anti-Semite. He's homophobic. Every single case that this man has ever touched is being demanded. The head of all the public defenders in Massachusetts has demanded a list of all of these cases so that every defendant who's either incarcerated or who has a case pending can be notified about it. What do you think about all this? Are you shocked?
I'm saddened for a lot of reasons. And I was comparing, because I had state troopers in the Brian Camp matter. And I try to keep my mind open for everything that I possibly can before I come to conclusions, because of my job and because of my life and because of, I just think that's the right thing to do. I think that, I know that, I used to jump to conclusions before I actually saw what was going on. And so I had the thoughts of, okay, this is horrific. Like, this is gross. Like, some of the pictures, there's one picture that the
picture of the little boy in the cage or the picture of the little boy in the toilet? Because there's both.
There is now, I don't know if you can, in your acting, you can cry on command.
I can.
I've been training myself to do so, and there's some stuff in my past that I go to that is what I will go to. That picture, unfortunately, burned into my brain. I'm going to try to use for, something positive. I mean, awful. It made me well up with tears. That's on your fucking phone. Excuse me, French. But as we're talking about all this First Amendment, defamatory slap and all that kind of stuff, it's one thing to say it, and it's one thing to think it, and I certainly don't like either one of those things. But ultimately, the question is, do you act on it?
Well, I think I'll keep talking because you're frozen again. Sometimes when you freeze, I can hear your voice. This time I can't. As a defense attorney, if you had a case, well, first tell me, if you can tell me both ways. If you had a case right now that was open, that was awaiting trial, in which Michael Proctor was the lead investigator, how would you use this? And if you had a client who's currently incarcerated, their case had been investigated by Michael Proctor, he was the lead investigator, and is now sitting in prison, what would you do? It's a two-part question.
Yes. And if you don't mind, I'm going to finish where I was going with that.
Oh, good. You froze, so I just had to fill the air.
I know. I appreciate that. In the Brian Camp case, there were state troopers all over the place, and there was a disaster that was created, but not by one particular trooper. That was systemic. The communication, in my opinion, between the state police and the local police to be able to get somebody there on time was the problem. It wasn't one particular trooper. In fact, on my cross-examination of the first trooper who arrived, I asked him, because they all had body-worn cameras, and I got to watch them get the call and start screaming to Chesterfield, which is where this happened, which is in the Boondocks. My question was, how long did it take you to get there? Because obviously I'm pointing that out. And his answer was, and I'll never forget it, longer than I wish it had. It took longer than I wanted it to. He didn't he wasn't doing, he wanted to get there on time and he didn't. That's different than this guy who has these things in his phone, and I don't know if there's those recordings that I hear or stuff like that. I mean, it's just one after the other, after the other, after the other. And this is a woman defendant in Karen Reed.
Mm-hmm.
This is the lead investigator, Karen Reed.
Mm-hmm.
This is the lead investigator who thought that this investigation into this woman was great. The one where people are throwing cell phones into dumpsters. The one where
Not people. One was a Boston police officer. One was an ATF agent. But that, they were just witnesses.
One where, speaking of body worn cams, on this, was it the second arrest?
Mm-hmm.
Where she is forced to come out in her basically pajamas and stand there being audio and video recorded.
Oh, you're frozen again. Right. And she asked if she could put underwear on, and Michael Proctor made some rude comments about all she cares about is looking good for TV. And also they snuck around to her back door to do this thing on body cam. They didn't even ring the bell at the front door. Okay, go on, you're back.
She's, her concern about, it's all on video, her concern about her health issue, that he was making such disgusting fun of in his text messages, and no nudes yet. I mean, and this is the investigation. So as a defense attorney who has had an investigation touched by this guy, I now see that, he acts on this stuff towards this woman.
Mm-hmm.
Because that was awful. And the fallout of that is such, and I wanted to say this, it's just so many people. This is your lead investigator. This is the way your lead investigator thinks. This is the guy who his supervisor said did however he described it, an investigation of integrity or whatever.
Honor
it is.
and integrity.
I mean, are you effing kidding me?
Mm-hmm.
And all of this stuff was going on, and thankfully, this is, the result was the right one. But
after two trials.
Yeah, I have a whole other set of things to talk about with regard to that situation. But the damage that this investigation did to so many people, and I read the complaint, the amended complaint that blames Karen Reed for
the defamation, right? The defamation complaint, yeah.
The defamation complaint that blames Karen Reed for no justice for John O'Keefe or his family, which is, in my opinion, the absolute furthest thing from the truth, because it was not Karen. There is no way, in my opinion, or anything else in my soul, that John was hit by that car. Certainly not anything that caused his death. It just
didn't happen.
What do you say?
It wasn't hit by John O'Keefe. Was not hit by a car. Car did not hit John O'Keefe. Okay. Anybody who's ever handled one car accident case can tell you that. Up. Buffering. Jessica says, Tom, I was Williston class in 1991. I also went to Western New England for college. Small world. Thanks, Jessica Whaley, for your 5.
Great
Tom's
minds.
frozen.
Great
okay,
minds.
You're back.
Great minds.
You were out.
Great minds go to the same school. And so, this whole time I've been upset with And I know that it can be hyperbole and people may think it, but the whole concept of the entire Commonwealth of Massachusetts being this terrible place for law and for trials and for criminal cases and for justice. And I sit here and yell at the screen saying, no, it's not the entire Commonwealth. Let me show you some examples. And then this crap comes out. And it's still not the entire Commonwealth of Massachusetts, but man, does he make it hard. Man, does he make it hard. And man, does a supervisor describe this investigation as being done with honor. And are you kidding me? Are you kidding me? And so the wrong person, in my opinion, was charged and tried. And I don't know who the hell the right person is, but in my opinion, it hurts the Commonwealth of Massachusetts, this investigation and this trial. I made a list. Obviously the entire state police, because this stuff is so bad. It is like it's got to be like a cancer.
It's a malignancy.
There are great state troopers that I cross-examine and that I'm friends with. There are great state troopers, but man, this one is bad. Makes local police look bad. Their own local police did that too, but the combination of the two of them. The legal system. Karen Reed obviously is a victim, but I think that there are two victims besides her that are the victims of this nightmarish investigation and this stuff that has come out, and that is John O'Keefe.
Yeah.
I was watching that bar video and I was like, this guy does not know he's about to die.
Right.
He's there with his girlfriend having a couple of drinks, and he does not know that he is about to die. And he's walking out the door to his death. I can't. And they charged, in my opinion, the wrong person. And my heart, it just breaks for. I've seen some comments and things that are said about them, but I mean, that's their kid. And, you know, I don't know if they believe, I don't know what they believe, but, you know, they're sitting there with nobody being properly charged, in my opinion, with what happened here. So, yeah, this was really bad.
You said you had a list, so tell us more. Obviously, they think Karen Reed hit John with her car because they're suing Karen and the bars under Dram Shop. And they did not sue anyone in the house. And I have been screaming from the rafters from the beginning that as a civil litigator, plaintiff's attorney, to not sue every single person who could be responsible and then sort it out later is textbook legal malpractice. The statute of limitations has expired on that. And so if it turns out that there are other people who wind up in handcuffs that are responsible for this, and it can be shown, they are out of the box on a civil case. Because I don't know how they're going to get any expert to come in and say that John was hit by a car to prove that wrongful death case, which is what they need to do. And my heart breaks for them too, because I think they've been sold a bag of goods by a district attorney and a bunch of corrupt cops. And listen, I'm not saying all cops are bad. Okay. I have law enforcement in my family. There are good cops, just like there are good priests and good lawyers and good doctors. And there's also bad ones. Nobody hates a bad cop more than a good cop. But in my opinion, not suing everybody in the house and everyone else who could have been responsible or should have been considered a suspect was a proper investigation done from the beginning. That's malpractice. Also, the fact that all of these people, Jennifer McCabe, Brian Albert, Brian Higgins, and Colin Albert, all being represented by the same lawyer is wild to me. Each one of those people has different interests. And the fact that they're all represented by the same lawyer, to me, is another recipe for malpractice. But get back to your list and then get
That
on
was
that
it.
soapbox, Tom.
That was it. That was my list. It just the stuff that came out. It's unbelievable. It's unbelievable stuff that came out in on that phone and wherever else they came out from. That the picture of the kid in the cage is.
And the I just passed an accident, but it involves a couple of N-words, so don't rush on over there. Let them die. That is said more than once in these communications.
I wonder. I hope that I don't know how long he's been a trooper.
Since about, I don't know, I think chat 2013, maybe 2012. A lot of these were undated. You're frozen again. A lot of these were undated, so we don't know when that comment was made. But if there's any good investigative reporters out there and they find out, they can dig into it and see, what that accident was and whether anybody perished, God forbid, in that accident because they took their time getting there, similar to Brian Camp's case.
Or other incidents,
right?
Prior to this, no. I mean, where people died. What was going on? Like, let them die.
Hitler sympathizers. Hitler had it right. That kind of thing. It's wild, and there are Massachusetts towns that have a large Jewish population. I think they spoke about one of them, naming Sharon as one of them. So it's like, oh yeah, if anything happens over there, it just people who are Michael Proctor supporters, Michael Proctor sympathizers say, yeah, well, all this stuff that he said was terrible, but what does it have to do with framing Karen Reed? What's your answer to that?
Well, that's what. I don't know the depth, although there's been a lot of evidence. I haven't seen every single part of the trial, but the way that he was talking about her, the way that they were treating her, coming out basically in her pajamas and just sort of overlooking, like how I just don't understand how everything from the butt dial, like it's okay. That there's an answer that there's 7 butt dials made and ended, and phones being thrown away, and it's just I don't think that what he was saying and had on his phone certainly steers anything away from anybody being framed.
The taint, though, that an investigator goes into with an inherent bias, such as freely displayed on his phone. The fact that somebody can type that kind of stuff freely to other people who are recipients of it, just like it's saying like, hey, want to meet for coffee, like, are you watching the game? Like the ease with these conversations were happening that were so grotesque and so horrific that just shocks the conscience of anybody who's a reasonable person, right? When an investigator walks into an investigation with those inherent biases, to me, it makes it more likely that he could frame someone. He admitted to it. He admitted he would plant a bag of coke on a guy. Does it strain credulity that he could also then perhaps go plant some taillight pieces on a lawn or have somebody else do it? I don't know. This is the kind of person that you're dealing with.
Sad, very sad for everybody.
You're frozen again. Anita Sandwich says, I agree. How many people of color died or didn't receive the help they deserved while on his watch because of his views, right? Right. And it wasn't just him, because he's talking to Sergeant Good of Canton PD, who was also one of the first guys on the scene. He was the guy with the leaf blower. He shot home, shot back, got his leaf blower, like no big whoop. They didn't find any red taillight pieces when they were blowing that snow around, but they found a clear cocktail glass. What do you say to someone who's sitting in prison who swears they're innocent, whose case was investigated by Michael Proctor?
Call the last lawyer that you had and request whatever it is that is about to be requested from. Follow. I can never say her name correctly. I read that.
Scapiccio.
Actually said hi to her in She represented the woman in the murder case in Northampton against Gagney.
Love Rosemary Scapiccio. She's like a
Yeah.
fireball.
Yeah, if I was ever jammed up, she'd be top 5 on the list.
Well, I'm calling you, but if you're not available, you know, it's going to be David Yannetti or Rosemary Scapiccio.
So if you were, so then you just got to dig out every single piece of whatever happened in that investigation and take a look at it all, knowing that the stuff was said in the phone, and you know, whatever other investigations will be taking place to see if there's obvious bias in the way that they investigated, whether it's the way she quoted, or not quoted, she stated that he wrote every affidavit for every search warrant against her client. Mm-hmm. We're talking about an African-American dude. We know what he said his thoughts are on those people. Mm-hmm. Like there's so much that you can say and do in the affidavit for a search warrant, whatever, phones or your house or your car. Take a look at that.
Would you take those cases? Let's say somebody's lawyer is, you know, retired or whatever. Are these cases that you can take?
Yes.
So they should call you, basically, is what I'm saying.
Sure.
And you handle civil cases as well, right? You've defended civil defamation cases, right?
I did.
Which brings us to our next topic about what do you think the chances of success are of the Jennifer McCabe, Brian Albert, Brian Higgins, Colin Albert defamation lawsuit that has been filed in, I forget which county. It was filed in Barnstable, actually. Look, we can talk about this too. So it's against Karen Reed and Turtle Boy Aiden Carney. You're looking at me like you're frozen, but I know you hear me. So I'll keep talking. It was filed originally in Barnstable. And I think the reason they filed it in Barnstable is because they needed Brian Higgins for jurisdiction purposes, because that's where he lives. And then it was, if they were forum shopping, it got transferred from Barnstable by the chief judge, who then picked it up and said, you know what, you're going to Plymouth because Judge Gilday is already handling a similar case in the O'Keefe wrongful death case. And so he's familiar with the players here. So it's now in Plymouth. But I sent you the amended complaint, and I wonder if you had a chance to look at it. It took me 20 hours to get through it with my viewers, the original complaint, because we clicked on every single footnote and watched every single video. 90% of the material that they hyperlinked was favorable to the defense. It's wild. But your general thoughts on the defamation causes of action that they've filed against Karen Reed and Turtle Boy?
I mean, likelihood of success is impossible for me to say, because I was skimming it as I was stuffing my face with salmon and asparagus for lunch today. So I was reading. I can tell you that it's well written. First thing I saw as a lawyer was that is a very well written document. And some of the stuff, and again, what's in the complaint, you know, set of facts, I don't know which is. I'm assuming that what they're writing down is what was said, because they're officers of the court. But again, some of it is pretty harsh stuff, which isn't particular, you know, it's a little distasteful for me with the stuff that was said, but that's not what the lawsuit's about. The question is it, you know, is it protected by, first time I ever looked up slap stuff was for this case. I had never even heard of it. But, you know, is it protected by Massachusetts and United States Constitution and the free speech? And, you know, a lot is, but there's complaints for per se, which is the criminal allegation. Very interesting 93A, which is the unfair and deceptive practices in business against.
Yeah, that was creative, right?
I paid a lot of attention to that one, because it's in the way that it's worded, it keeps talking about money And, you know, they're saying the reasons that he was doing that, and his reason was money, and her reason was, you know, trying to defame people.
Boop. There you go again. I'm like on the edge of my seat waiting to hear what you're going to say next. Oh, wait. Okay. You're back. Money. They were saying money, and she was saying she was just trying to defend herself. And she really wanted to try and find out who killed her boyfriend, Boston police officer John O'Keefe, because he wasn't hit by a car. And so you're still frozen. Happy anniversary to us, Caroline Dwyer. Good Citizen Weymouth, that you're talking about the Brian Camp case. I think you put this super chat in before he told us who the judge was, and he was on the bench, and we played the little clip, and I forget his name at this very moment. Girl Ryan, thanks for your 10. Says, I remember washing dishes and listening with my headphones on when the verdict came back. I can confidently say I don't distinctly remember any other sink of dishes. Happy Sunday, y'all. Thank you for your 10. And Brian Camp became our collective adoptive son. Tom, you're still frozen. Craftastical says, time your show for when Melanie is finishing. She can redirect us over to you. Great way to build subs and views. Best of luck, Tom. I don't know if he's going to do live streaming or if he's going to do, record videos and put them out that way. So thank you, Craftastical, for your 5. And he went out and he's going to come back in. It's Steph on the Cape says, I'm so glad there's more cupcakes here on the Cape. Tom, it's good to see you here. Frozen or not, I subscribe. Looking to more of you both. Thanks. Okay. Oh, yeah. Sometimes that works if you go out and come back in. Can you? Are you looking at yourself now, or do you realize?
Sunburn. Look like I'm sunburned.
Oh, yeah. Living by the beach really sucks, doesn't it?
One of the takes I have on this whole thing, and again, it's sort of in a macro sense, that none of this, in my opinion, none of this craziness, everything that's contained in this complaint that you sent me against Karen Reed and Aidan Carney. I mean, in my opinion, he wasn't hit by a car. It wasn't a car that killed him. Let me see if I can be careful the way that I say this without, the whole idea of these days in the law, and the civil case that I had, the defamation, intentional infliction of emotional distress case that I had, was with Judge McDonough, who was a big time civil litigation. I think he was.
Damn it. Every time you go to see something really good, you got to get internet. You got to get Ethernet, dude. Tell me who to call. Who's your provider? Fios? Optimum?
He pushed hard for making things simpler, including the jury instructions, which is, I told you that I printed them out in case you wanted to hear some of them.
Sure.
And as I have gotten older and gotten more experience, I make my cases simpler. The first thought is, oh my God, I need all of this as a defense attorney it's not our burden. This case was a lot simpler, in my opinion, than it actually turned out to be, because a jury is ultimately wound up seeing, after everything was sort of cleared away, like the third party stuff, I think was, in my opinion, I was yelling at the screen when they were doing the third party culprit, because I don't think it was there.
That's what I said the first trial too. I said after the first trial, the jury shouldn't be trying to solve a mystery of who killed John O'Keefe. Okay, they have one question: was John O'Keefe hit by a car? If the answer is no, we all go home, and that's it.
So, but again, that wasn't my case, and it's my opinion. But I was just like, "What are you guys doing?" And sure enough, man, I mean, it was. That first case was, my understanding was that it was closer to conviction than acquittal. Correct me if I'm wrong.
Yeah, there's been a lot of split decisions on that. A juror from trial number 2 recently came out and had some interesting things to say. He's like, that guy wasn't even hit by a car. I don't even know what they were talking about. But I think you're right. I think it was muddy in the first trial, and there's been differing reports on whether it was like 9-3 or 8-4 to convict. But I don't know if anybody really knows the answer to that.
And so, in my opinion, in this case, armchair criminal defense lawyer, that is a good example of it being more complicated than it needed to be, and I think that was borne out in what wound up happening, the nightmare of the whole strange jury, the verdict slip, and all that kind of stuff. But anyway, that caused a second case, which was pared down, and I can't remember if they got rid of the third party or it was like limited third party culprit.
It was limited. They couldn't point to Colin Albert in trial number 2, but I think that they also focused on there was no collision, right? The first opening in the first trial was Karen Reed was framed. David Unetti's opening I thought was brilliant, but in the second trial is the opening was by Alan Jackson. There was no collision, and I think the shift was important.
That's the
Damn it. Thank you, Lisa G. Lisa G6 gifted 5 memberships. You're amazing. Thank you. All right, you're back.
Framed
the
is,
shift in strategy, the shift in trial strategy.
Yeah, framed was too. It's a quasi burden shift when that's going on, and it just framed, horrific investigation. Not necessarily, I mean, which could be so bad that it looks like it's a framing. That's kind of what this is to me.
Mm-hmm.
I don't know that framing is what I would, it's not helpful that, well, I don't remember if she said that she did say I hit him, or did I hit him?
She said, did I hit him? Could I have hit him?
Right. So, if it was pared down initially, I think that the likes of Jackson and Unetti et al., without that other stuff, would have crushed them in the first trial. I think that all the other stuff got too complicated, and then the jury didn't know what to do. The second one was much better, but in that regard, in my opinion, none of this stuff. I was also yelling at the screen for them to please stop doing interviews. Karen, I stop it. Stop, because it's not going to help. She might have, I believe one of the was it the foreman of the jury said that one juror or 2 jurors didn't want to even acquit her, or didn't want to convict her of the OUI.
Yes.
Some of the stuff she said in those interviews was,
right.
So I just was like, stop talking. And I don't think it was necessary. All this stuff was necessary for the second trial, because it was pared down, and it was clear to me as I was watching, this theory was not going to get beyond a reasonable doubt. And in my opinion, the injuries that I saw and their own medical examiner was helpful in that regard. Like it was a lot simpler case than it turned out to be, in my opinion. But here we are. And so I didn't think that it was necessary to have all of this stuff being done.
Damn it. Yeah, all of the extra gives him too much to think about. Was he hit by a car or not? If he wasn't hit by a car, the answer is no, we go home. All right, you're back.
But here we are.
Mm-hmm. And now we're seeing all of the bias and all of the corruption and all of the taint that was on this investigation from day one. The house was never searched. The woman, Jennifer McCabe, who pulls up in the car as a passenger with Karen Reed in the backseat screaming. Karen sees John's body. Jennifer McCabe's sister and husband are in the house. Brian Albert, who's a Boston police officer, is a member or, heads up the fugitive task squad unit, right? So he's chasing after dangerous criminals all the time, undercover maybe and whatnot. And her dead friend is found on her sister's lawn, and she doesn't run into the house to see if her sister was okay and her family was okay. To me, that screams sus. And she claims she called her sister twice. Her sister didn't answer the phone. How do you know that everyone in that house is not dead or killed by a fugitive? It's just, to me, a lot of this stuff that they say, they've been scorned, their reputations have been ruined. They are now, pariahs of the community. They've been excommunicated. Everyone hates them. Much of this was brought about perhaps by their own behavior. And so to try and sue Karen Reed and Aidan Carney for this conspiracy to commit defamation against them is just, it's kind of wild to me when not everyone has been brainwashed by Aidan Carney. Many people watched this trial on their own. They read the papers on their own. They watched the hearings and they saw the injuries and they listened to the experts. And they too know that John O'Keefe was hit by a car. Therefore, Karen Reed is innocent. Therefore, perhaps what Karen Reed and Aidan Carney have been screaming about has some beads of truth. And I know that you had pulled up, you said that the jury instructions for the defamation causes of action. Actually,
yeah, I was going to ask you if you were, because I'm more interested in the anti-slap because that's coming first, if I'm not mistaken. Do you know if discovery has stayed and all that stuff?
No, because the weird way that they do the motions there in civil court is that the whole package gets submitted to the court after the reply is, or, the opposition comes in and then the reply, then they submit it. So I know that Aidan Carney filed an anti-slap motion, but we can't see it yet because it's not part of the docket.
Right. So want to hear a little bit about what I learned about?
Yeah. Tell me about petitioning activity.
Okay. And I think I actually found out specifically for blogging and online, the central issue for internet journalists is what I found. So, because.
All right, hold that thought for a second there. Hold that thought. I didn't realize there was a separate instruction for. Okay, go on for internet bloggers.
It's not instruction. It talks about, I'm talking about just the anti-slap statute, which I didn't know existed. And I looked up specifically for Mr. Carney because it's an interesting issue. So Massachusetts enacted its anti-slap statute in 1994, Commonwealth versus ExxonMobil. Over time, the statute's broadly drafted provisions, particularly its wide-ranging definition of petitioning activity, led to a significant expansion of its application well beyond the permitting context. Statute permits any party to bring a special motion to dismiss when civil claims, counterclaims, or cross-claims against the party are, quote, based on said party's exercise of its right to petition under the Constitution of the United States or the Commonwealth, except cases brought pursuant to blah, blah, blah. Court advance, blah, 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 expeditious, blah, blah. Motion must be filed within 60 days of service or if the judge lets you extend it. A critical threshold limitation distinguishes Massachusetts statute from those of many other states. Unlike California's anti-slap statute, which protects a broad range of free speech activities, Massachusetts statute protects only the, quote, right of petition, not all First Amendment rights. This distinction has significant consequences for internet journalists whose activities may implicate free speech and press rights, but may not always constitute petitioning in the constitutional sense. So it appears as if petitioning is going to be. You're going to say something?
No, I'm just listening to you.
What constitutes quote unquote, petitioning activity, end quote, under section 59H? The statute defines a party's exercise of its right of petition to include 5 categories. 1, any written or oral statement made before or submitted to a legislative, executive, or judicial body or any other governmental proceeding. 2. Any written or oral statement made in connection with an issue under consideration or review by such a body. 3. Any statement reasonably likely to encourage consideration or review of an issue by a governmental body. 4. Any statement reasonably likely to enlist public participation in an effort to effect such consideration. Or 5.
Damn it. All right, you're at number 5. Okay, you're at number 5.
That was it.
Well, I didn't hear number 5. You froze at number 5. So you got to read number 5 again.
Number 5, it's like a broad net. Any other statement falling within constitutional protections of the right to petition government.
Okay, so all of those things are permitted under the legislation.
Those are the things that have to be. One of those things has to be one of the things that's being done for it to be exercising the right to petition. The quote own behalf requirement. This is what it confused me and it interests me. The own behalf requirement, the central issue for internet journalists. The most consequential limitation on anti-SLAPP protection for internet journalists is the requirement that the movant must be exercising its own right of petition, speaking on its own behalf in its status as a citizen seeking some redress from the government. So speaking on his own behalf, and quotes a case. The requirement established by another case applied repeatedly since is the fault line that separates protected from unprotected online journalism. So own behalf is big, and I can't quite understand how it's defined, but there's a couple of cases here. It's a print journalist, environmental activist. The early case of established that operating an internet website as a public forum on local governance issues can constitute protected petitioning activity. Yeah, that's just a website. The Supreme Judicial Court held that a paid print journalist who wrote objective, factual news accounts of neighborhood meetings could not invoke the anti-SLAPP statute. The journalist had written 5 articles about a developer's properties for a community newspaper. She expressly stated in her affidavit that she was, quote, always careful to present an objective description of the subject matter, end quote, and that her personal views were not reflected in the articles I wrote. The SJC held that because she was not seeking to redress a grievance of her own.
Oh, damn. All right, because she was not seeking to redress a grievance of her own. That's where you cut off.
Yeah.
Go on.
The court also rejected her argument that she was a, quote, messenger for community groups whose petitioning activity she was amplifying, distinguishing journalists from attorneys who expressly represent clients as their agents. The court noted that, quote, there is nothing about the role or function of a staff reporter of an independent newspaper that by its nature renders the reporter a representative or agent of every or indeed any community organization that the reporter may cover.
Okay.
So was he or were they doing what they were doing, assuming in the light most favorable to the plaintiffs that what's in there is true? Was this being done on his or their own behalf? Online content that does not qualify as petitioning. Not all Not all online publication qualifies as petitioning activity, even when it touches on public affairs. The appeals court held that a former city councilor's insulting Facebook post directed at an attorney, made in the context of a broader discussion about an upcoming municipal zoning hearing, did not constitute petitioning activity. The court found that the challenged post contained, quote, no objective indicia, end quote, that it was made to influence the government proceeding or to enlist public participation. Although the defendant's initial post was in exchange, post in the exchange likely did constitute petitioning, it criticized the city council's scheduling of a hearing and arguably sought to enlist public attendance. Sounds familiar. The subsequent personal insult had, quote, veered off course, end quote, and lacked any cognizable nexus to influencing government action. The court rejected the argument that insulting one's opponent is, quote, part and parcel of petitioning activity. The cases collectively established that the key inquiry for an internet journalist is not the medium, in parentheses, blog, website, comma, social media, but the nature and purpose of the content. Does it express the journalist's own views? Is it directed at influencing or enlisting participants?
Oh, hold on. Is it directed at influencing or?
Mental proceeding, or is
Hold on,
it
wait, go back. Is it intended to influence, or that's where you cut off?
Is it directed at influencing or enlisting participation in a governmental proceeding, or is it objective reporting, personal commentary unconnected to government action, or content written in a professional capacity on behalf of others?
Well, it seems to be connected to government action because he's taught a lot. Everything that he talks about is how shoddy the investigation is.
But is it his own? It's the ultimate question. Is this on his own behalf?
Well, are you saying that because he's speaking out? Well, I mean, they're trying to show that he and Karen were colluding, but it's not illegal or improper for a criminal defendant to work with a reporter, right?
Correct.
So there's nothing improper about that. They also try to pull the attorneys in a lot, even though they're not suing the attorneys. They try and pull David Yannetti and Alan Jackson in there a lot.
No, they don't try, they do.
Yeah, they haven't sued them, but
Right.
they do, they are pulling them in a lot. And there are some definite things that are in that complaint that are not accurate. That they, David Yannetti, some text messages where they claim that he was calling the investigators like bastards, but that he was calling them bastards, the plaintiffs, but really he was referring to the investigators. What are your thoughts on that?
I can't quite put my brain around the own behalf.
But he's speaking on a matter of public importance, right?
Yeah.
To an audience, many of whom are local to where this trial is happening and this investigation is happening. And so he also lives in Massachusetts. And so he is also outraged by the corruption and the possible frame job and conspiracy that he has uncovered. And so I think that in that sense, he is speaking on his own behalf and on the behalf of everyone who lives in the community who's affected by these corrupt POSs. Well, and then the plaintiffs, like everything he reported about the plaintiffs was in public court filings. It's not stuff that he just made up out of whole cloth. And he said, okay, this one's a murderer, that one's a murderer, that one's a murderer. This one covered it up. They punched him and dragged him out there to die in the snow because he did so much of his own research about the Ford Edge that was parked outside in front, and all of the stuff that he was reporting was journalism. And so I don't know when that crosses over the line to defamation under anti-SLAPP. But under common law, I mean.
Neither do I. And I'm glad that I've not had to argue against you in court.
Well, they're threatening to sue me too. So you might get to represent me. So, there's that. I mean, I feel like he I don't think that he was speaking out on Karen's behalf or on the, on the defense's behalf, because all of this stuff was made public. And if you can sue someone for defamation every single time somebody says something mean about you, the courthouse steps are going to be pretty clogged up with frivolous cases such as this. And the other thing is, what I found very interesting is these particular.
Hang on. Tell me if I'm doing this right.
You have to say hold please, because people with misophonia are going to get really mad if they hear you swallow. Oh, it's bad. You should not swallow in the microphone.
What is misophonia?
Oh, I know.
I don't mean to laugh at anybody's condition. I'm sorry. But what
you're going to get, they're going to clip that. It's going to be all over Twitter and you're going to be hated by morning. Trust me, I've been there. I can help you. It's a thing where people get very triggered by listening to certain sounds like lip smacking or swallowing, and to the point where it drives them mad and they have to.
So me, I didn't realize that I had that.
You have to mute the microphone. Oh, you have that problem too?
There are certainly some sounds that sort of make my gag reflex kick in. Sure.
Like Adam Lally's voice. See, now I got sidetracked again. Goodmans, thank you for gifting 5 memberships. I love you guys.
So one question I have for you is because you guys all read it slowly and
with intention.
Yes, but the way it's I wish I could write like it's written. It's very subtle, but it seems to touch on like, oh, I know what they're doing here. Did you see any specific arguments about public versus private people? I didn't see go ahead.
Do you think? I think that they, for purposes, could be limited purpose public figures, but that hasn't. I want to see the motion papers because we haven't been able to see those yet. And the only thing that you read, I think, is what I sent you was the First Amendment complaint.
And there's not been an answer. Has there been an answer?
No.
Okay.
Because I think they filed a motion in lieu of an answer, but we just haven't seen it yet.
Okay. Yeah, I think the way that it's worded, they obviously are arguing that their clients are private, not public.
They didn't specifically touch on it at all. But I mean, when you're involved in such a public trial with worldwide interest, and also Brian Albert was on a reality show, he was on a reality show called Boston's Finest. So could that in and of itself make him a limited public figure? And this is like, I don't know if you watch South Park, but up in the corner here, I think it's here, maybe it's there, is the Prince Harry and Meghan Markle privacy tour. They wanted their privacy. All right, lost you for a second there, but you could probably hear me the whole time. The way this is pled also, especially with the footnotes, like a lot of it is misleading. And then the footnotes have an entire video that puts more context into the statements, And Aidan Carney going around in his peaceful rolling rally, asking them to just tell the truth, is that not petitioning activity? Tell the truth when you get up on the stand. Tell the truth in this court proceeding. It's definitely an interesting legal issue. And I think it's one that's not litigated very often. Yeah, the slap stuff, for sure. I'd never even heard of it, but now I have. And I'm more confused than when I didn't know about it. I mean, it's intended to, allow people to speak out against the government without the government suing them for speaking out against them, like in some communist countries, perhaps. I mean, it's relatively new in New York, too. California has been very big on anti-SLAPP for a long time. But it seems that Aidan's attorney, Mr. Pyle, is an anti-SLAPP expert. So I'm anxious to see the papers, and we can look at them again. Yes, I'm going to probably plagiarize them in the future. You mean the motion papers or the complaints? Probably all of it. Have you guys read what the jury instructions are for defamation? No, I was waiting for you. Oh, I didn't. Thanks, Unbanned Karen, for your 20. I appreciate you. She says I'm a queen.
Want to hear what
Yes.
I would sound like if I was a judge?
Common law defamation. Please, I can see you as a judge. I think that should be your next role on Law and Order or a Boston show. We'll get back to this al dente in a minute. All right. So this is just for common law defamation. With
a private person.
Yes.
I have to get it set up so that my head isn't out of the screen when I'm trying to read. How many screens do you have there behind the
I have a
curtain?
giant screen over here, and then I have a giant screen in front of me.
All right. I have 2 laptops, and it's not.
You got to get the giant screen, the curved one. I set you up. I sent you the whole list of equipment.
All right. Okay. I'll get on it.
You got to spend money to make money, Sam.
Oh, yes.
Don't be cheap.
Plaintiff has sued defendant for making false statements about him/her/it concerning, and these are the simplified jury instructions, which are helpful to jurors and lawyers concerning described.
Yeah, you just cut out again. Concerning classic overthinker says, do you know what happened to Richard Allen pretrial? I don't know who you're talking to, me or Tom, but yeah, I do. Okay, go on.
I don't know who that is.
Oh, Richard Allen, the Delphi case. He was like put in solitary in prison for years and then starved, and it was a whole thing. All right, go on.
As you have heard during the trial, we call this type of claim, quote, defamation. To prove the defamation claim, plaintiff must show, more likely than not, the following 4 things are true. 1, the defendant made, in parentheses, actually in brackets, published, posted, emailed, etc., a factual statement about the plaintiff to someone else. 2, the statement was, in brackets, false, there's a long footnote, and could harm plaintiff's reputation in the minds of a substantial number of respectable people, that's in brackets, in the community. 3, defendant was at fault for making the statement. I will explain in a minute what it means to be at fault. And 4, statement caused plaintiff economic loss.
I think they fail on point 2. They have to show it was false. Turtle Boy's in the chat. Hi. Hi, Aiden. Right? In order to prove defamation, they're going to have to show that the stuff he said was false. He said Jennifer McCabe had a horse face. Well, that's hyperbolic, right? I mean, that's, obviously she doesn't have a horse face, but, that's like, they have to prove that they had nothing to do with the cover-up of the murder of John O'Keefe. They're not going to be able to prove that unless they have, Colin Albert's going to have to give up his phone records with all of his location data to prove that he was somewhere else. And I don't think that's going to happen.
4, if applicable, the statement was, in brackets, was in writing, accused the plaintiff of committing a crime, claim that the plaintiff had, these are the per se things specifically, which I didn't know about sexually transmitted disease. I had no idea.
Yeah, that's defamation per se, as is calling a woman, saying that she cheats on her husband.
Statement was in right. Claim that the plaintiff committed a crime. Claim that the plaintiff has an STD. Named the loathsome disease. Harm the plaintiff's profession or business. Or called her.
Tammy Dubé pointing out that the Lower Cape has horrendous service. It sticks really far into the Atlantic. That's his excuse, and he's sticking to it. Okay, you're back.
I heard about this thing called the Ethernet, though. So
yeah, you got to get the Ethernet. That's the key. Every streamer, Ethernet is key. You can tell who has it and who doesn't.
Making a factual statement about the plaintiff. First, the plaintiff must prove that the defendant made, published, posted, emailed, etc., a factual statement about the plaintiff to at least one other person. Plaintiff does not have to prove that the defendant made these statements to a large number of people. However, defendant is not liable for a statement that he, she, it made only to plaintiff and to no one else. Then there's defamation by conduct. I don't know if that's, I don't think that's in the, I didn't see that in the complaint.
Here, Turtle Boy is here. He says, my reporting and activism was the catalyst for the Canton Police audit town meeting vote, which is government petitioning.
There's your answer. Go ahead.
I was just going to say that I think a reasonable person, and I mean, there are like at least 4,000 reasonable people here right now in the chat, would come to the same conclusion. That these plaintiffs had something to do with either the murder and or cover-up of John O'Keefe because he was not hit by a car. And who Googles Haas Long to die in cold at 2:27 a.m. without a reason? She admitted under oath that she lied to the FBI. Jennifer McCabe did. Kerry Roberts admitted under oath that she lied to the grand jury about hearing Karen Reed say Google hypothermia, which she never did hear. She just knew about it. There's just so much sus behavior, and the cumulative effect of it all is that all of this stuff was in public court documents, and he was reporting on it. Karen Reed was trying to defend herself because somebody, like you said, needed to find out what happened to John O'Keefe. Because the Massachusetts State Police and the Canton PD didn't give a shit. They didn't care. The murder of a Boston police officer, and this is the kind of investigation he gets. Not that every murder is not important, but in New York, it goes to the top of the pile, okay? And everything stops, whether the cop is on duty or not. It's outrageous what they did. All right, you're back.
I would probably say stop yelling at me if we were arguing in court.
Oh, I'm not yelling at you. I'm just talking to the chat.
I know.
Talk.
I know. Statement must be about the plaintiff. If it did not refer to the plaintiff by name, then he, she, it must prove one of the following two things. Plaintiff must prove that the defendant intended the words to refer to plaintiff and that someone other than the plaintiff understood that they did refer to plaintiff, or, that's interesting, or plaintiff may prove that the defendant was negligent in making the statement in a way that a reasonable person could interpret as referring to plaintiff. I don't think that's pled.
That's not a problem. It's pretty clear who he was talking about. He doesn't mince words.
Plaintiff does not have to prove both of these things, but must prove at least one of them. If applicable, define negligence, adapting instruction for negligence, general section, blah, blah, blah. Fact versus opinion. Defendant's statement must be factual and not purely a matter of opinion. I think now we're getting into the meat of things. Not purely a matter of opinion. Everyone has a constitutional right to express an opinion as long as they do not make false statements of fact. No one commits defamation by stating a pure opinion, even if it is harmful or offensive. And therein, as I read the complaint that you sent me, that's sort of, as I read the whole thing, certainly some people could take things as harmful or offensive, but doesn't necessarily rise to the level of defamation. This is kind of the meat of the whole situation. As long as they do not make false statements of fact, no one commits defamation by stating a pure opinion, even if it's harmful or offensive. In some cases, though, a statement that sounds like an opinion may also communicate a fact. Plaintiff must prove that a reasonable person could have understood defendant's statement as making a statement of fact rather than a pure opinion. That's murky.
Yeah, I mean, I think even if you say Jennifer McCabe is a murderer and you state it as fact, that could also be construed as your opinion.
In deciding whether a reasonable person would understand the statement as a fact or an opinion, you should consider all the circumstances, and you may ask yourself questions such as, was it possible for a defendant to verify the statement? This gets into my defamation case that I defended. And one of the biggest differences between my client and, I think I told you everybody was an actor, right?
Mm-hmm.
I'm in a movie with the plaintiff. I've been in 2 plays with my client. I don't know the other defendant, but if you know, in criminal cases, it's often true that you got to dance with the one you brung. With regard to a client, I had one of the greatest clients you could possibly have in a case like this. She went and investigated and asked people and double checked and triple checked and before she said anything, and that's why the jury found her not liable for anything. But was it possible to verify the statement? Generally, it is possible to verify a statement of fact, but not an opinion. Where and how, and this is new to me, that the judge is telling the jury, you might ask yourself these questions. Where and how did defendant make the statement? Sometimes the location or method of making a statement is more appropriate to stating facts. Other methods and places may be more likely for expression of opinions. Next one, who was the defendant speaking to? Next one, what? That's not, somebody did not write this well. What else did the defendant say? Did the defendant give any cautions to the listeners that might lead a reasonable person to think that statements were matters of opinion? Did the defendant communicate in some way that he, she, or it was asserting facts? In general, you should consider.
And generally, you should consider. Dun, dun, dun. Okay. And generally, you should consider.
In general, you should consider the statement's context carefully, because a statement of fact in one context can be a statement of opinion in another. For example, if the setting is one in which the listeners can expect speakers, writers, to try to persuade listeners or readers through fiery rhetoric or emotional language, people might understand a statement to be a matter of opinion, even though in a different context, the audience would consider it a statement of fact.
Isn't that a classic? That's classic Turtle Boy, right? Read that again, if you don't mind. I don't want to boss you around, sorry.
Yes, you do. That was a lie. My goodness.
Go on. I'm usually the one doing all the reading. This is good for me that you get to do some reading tonight.
In general, yeah, this was as I was reading the complaint, this kind of struck me. In general, you should consider the statement's context carefully, because a statement of fact in one context can be a statement of opinion in another. For example, if the setting is one in which listeners can expect speakers or writers to try to persuade listeners or readers through fiery rhetoric or emotional language, people might understand a statement to be a matter of opinion.
There you go.
Even though in a different context, the audience would consider it a statement of fact.
Fiery rhetoric. That's his brand. That's Aidan Carney's brand.
Based upon all the circumstances, you must decide whether the plaintiff has proven that a reasonable listener would consider defendant's statements to be statement of fact, not just pure opinion. I don't think we have any, no.
But he believed everything that he said to be true, and he still does, as do many, many, many people in this chat. How can they prove? So they have to prove that they did not kill John O'Keefe in order to say that the things that he said were lies and not opinion. And Karen Reed has been acquitted.
B, statement's falsity and or tendency to harm reputation. The second thing plaintiff must prove, more likely than not, is that the statement in parentheses was false and in parentheses could harm plaintiff's reputation in parentheses in the minds. I don't know where this is coming in. I'm going to read this.
You broke up again. In the minds. Wouldn't they have to show that their reputation was good to begin with? Because if your reputation isn't good, then how can someone damage it? Okay, you're back.
Yeah, that would mean I couldn't be defamed. A statement, so I don't like keeps going back to substantial number of respectable people. The second thing plaintiff must prove, more likely than not, is that the statement was false and could harm plaintiff's reputation, in parentheses, in the minds of a substantial. Oh, I think we're going back and forth between private and public.
Right, but again, the burden of proof is on the plaintiff always, right, when you bring a case.
But between one person and substantial. Quote, a statement is defamatory if, quote, it may reasonably be read as discrediting the plaintiff in the minds of any considerable and respectable class of the community. Okay. And that's from 2009. Omit this paragraph in cases where truth arises only as a defense. I believe that's a defense, although we don't have the answer yet, correct?
There's no answer. No, they're moving in lieu of an answer. I think they're going to make their anti-slap motion. They've already made it, just hasn't been filed because they gave them an extension to answer, at which point discovery will be stayed pending the decision on the anti-slap motion.
If appropriate, you must also decide whether the harm to plaintiff's reputation occurred among a respectable part of the community. For instance, suppose I said that a person is an honest, law-abiding citizen. That might hurt the person's reputation among armed robbers. What? I don't remember this during my trial. Suppose I said that a person is an honest, law-abiding citizen. That might hurt the person's reputation among armed robbers who thought that they could rely upon him to help them commit crimes. But the law does not allow recovery in that situation because the community of armed robbers is not respectable. Keep in mind that the plaintiff does not have to prove that the statement harmed his or her reputation in the entire community or among all respectable people, reasonable people, sorry.
Mm-hmm. Listen, Turtle Boy's just a normal soccer dad. How can he intimidate anyone? Also, don't you have to know that you had a good reputation to begin with in order for your reputation to have here's the damages part here is really what's going to confuse me, okay? Nobody lost a job. Jennifer McCabe was just a normal soccer mom. She was, not that being a stay-at-home mom is not a job. It is, but you don't get paid for it. Brian Albert retired. Brian Higgins, we don't know what happened to him, but I don't think he was ever taken off the payroll. And Colin Albert was a student. So nobody's lost any income. All right. They've got no tangible damages. And so how are they going to, even if they can get over causation, which I don't think they can, even if they can get over proving that there's anything defamatory about it, I think they're still going to fail on damages because a lot of the damage to their reputation was not done by Turtle Boy or Karen Reed. It was done by their own suspicious actions, behaviors, statements, etc. Not by Aiden and Karen.
Last thing I'm going to read if you want to hear it. It's called defamation damages. Jury instruction. If plaintiff proves all four things I have just described, plaintiff must prove the amount of damages caused by the false and damaging statement. By instructing you on damages, I am not suggesting anything about your answers to questions X or Y. The purpose of damages is to compensate plaintiff for the harm done by the false statement. You may not award damages for the purpose of rewarding plaintiff or punishing defendant. That's for other counts. As with the other elements of its claim, plaintiff must prove that.
Does it really say it in the jury instruction?
Yeah, probably corporation.
His, her, or it? Oh, because you can defame a corporation? All right.
Or we're being, I don't know.
So if I say Delta Airlines sucks because the flight prices right now are out of control, they're going to sue me for defamation? Okay, go on.
As with other elements of his, her, its claim, plaintiff must prove that more likely than not defendant's conduct caused the damages. You should not award damages for any harm that plaintiff or someone else other than the defendant caused. Types of damages. There are several types of damages you should consider. You should award damages for any out-of-pocket loss that the statement caused the plaintiffs to suffer. Plaintiff is also entitled to damages for plaintiff loss of reputation in the community, emotional distress, personal humiliation, shame and disgrace, and mental suffering caused by the statement. When evaluating these types of damages, you may consider, among other things, the following factors: the nature and type of the alleged harm, severity or extent of the harm, the length of time plaintiff has suffered and reasonably expects to suffer, and whether plaintiff has attempted to reduce the harm, for instance, by counseling or taking medication. That was a really interesting damages part in the case.
They're going to have to call witnesses that they've all been in therapy and they're afraid of Aiden Carney, and good luck with that.
You should award damages. You should award damages for any specific economic loss resulting from the false statement. For instance, you should award damages for lost wages, benefits, or lost business for customers and clients. You should also award damages for loss of economic benefits in the future. You're frozen now. Such as the inability. You're disappeared on my end. There you are. For cases involving slander per se, I don't think we can't award zero. You must, I think you have to at least award $1. Future damages. If the plaintiff has proven more likely than not that in the future he or she will suffer any emotional distress, loss of economic benefits because of the false statement, you should award damages for the future harm. If you find plaintiff will suffer damages throughout his or her lifetime, you may consider life expectancy tables and evidence to determine how long he or she will live. Wow. There will be no future trial to consider any future damages that plaintiff may suffer. You must keep in mind that any judgment in this case will be paid in a lump sum. I've never heard this one either.
Yeah.
Will be paid in a lump sum and may be invested and earn money. I've never heard that one. Therefore, if you award future damages, you must reduce that portion of the damages to its present value of this year when plaintiff filed the year that the plaintiff filed this case. Retraction and mitigation, if applicable. Defendant claims that he or she retracted or took back the false statements by describe the action. Defendant claims this later statement reduced the amount of the damages that plaintiffs suffer. Unlike the issues I have discussed earlier, defendant, not plaintiff, has the burden to prove that more likely than not, the retraction occurred and reduced, shortened, or eliminated plaintiff's damages. If defendant has proven these things, you must remove from your award any damages for any potential harm that the retraction prevented.
I don't think it's going to get to damages. Let's answer some questions, shall we? Oh, the other thing I was going to tell you before, and I don't know if you know this because I think you froze. The other suspicious thing here, not suspicious, but so Proctor's phone extraction just came out, right? And many people have it, including Rosemary Speechko. We learned a lot more about that in the recent filing that came out, the unsealing of the motion in the Miles King case. And the House plaintiffs have moved to have all of their communications with anybody who works at Norfolk County DA's office under a protective order and sealed. So nobody's going to get to see it. So that begs the question, were these people, Brian Albert, Brian Higgins, Colin Albert, and Jennifer McCabe, texting with Michael Proctor? And could some of their communications be in Proctor's phone, number one? And if that stuff comes out, forget it. This is over. They should just pull the plug on this case and just walk away. And thank God they're not going to be arrested for whatever in Michael Proctor's phone, perhaps. And also, they could also have had communications with Michael Marcy, the victim witness advocate, Brian Tully, Kevin Albert, well, not Kevin Albert because he's not. Wait, Kevin Albert doesn't work for Norfolk County DA's office. It's just the MSP, and Lally and Brennan, and God knows what's going to come out there, things that these people might have said. And so therefore, that too begs the question is, what are they afraid of? What are they afraid of that it could be in Michael Proctor's phone that they said in communications to him and that perhaps could have caused two of them to destroy their own damn phones? And now who's really mad as hell at Michael Proctor for not being able to effectively delete his communications every 30 days like he told the judge? Those are just my thoughts. But you don't have to answer that. Gertrude Boys, good. Mo wants to know.
I said good.
Mo wants to know, could Turtle Boy's rallies outside government buildings be connected to government action? He rallied citizens to an injustice for Karen Reed. Is that petitioning activity?
That's the ultimate question. I do not know the answer to that question, even after reading that research that I found.
Yeah. And is that a question of law, a question of fact for a jury?
That sounds like jury. That's a question of fact.
Right. Toby's mama wants to know, could Tom be freezing because of having something on the same tab in StreamYard? Oh, I don't know, maybe. So if you have StreamYard in your browser open and then you try and look at another tab in the same browser, it'll freeze. Maybe that's what it is, but
any other tab?
Yeah, so you have to have StreamYard like in its own separate browser window. Otherwise it screws you up.
Well, we'll see right now because I had emails open.
That could be. And if you were looking at that stuff while you were on with me and you flipped over to a different screen, that could happen. Thank you. Thank you very much, Toby's mama, for your 5. And what does Tom think of the House defendants all having one lawyer? In the case where Karen Reed is suing everybody for civil rights violations, she's also suing Brian Albert. I forget who exactly the defendants are in that case, but they're all represented by the same lawyer. Which I thought was a recipe for malpractice, but because they all have differing interests. You know, Brian Albert owns the home. Nicole Albert owns the home. Jen McCabe was a visitor. Nat McCabe. I don't think it's a good idea. Thoughts?
Thoughts are that at this point, that's between the lawyer and the clients. Even if there's a conflict, the client can sign away, can waive the conflict if there's a full-blown discussion. At some point, if there winds up being a conflict that a judge is concerned about, a judge can take action. That's actually.
You froze again. That's why Judge Canoni would not allow Mark Betterow to pro hoc in on the Karen Reed defense, because she said because he represented Aiden Carney, she found it to be a conflict and she wouldn't let him in.
Yeah, so before I froze, I just took over a case from a lawyer who was had an agreement with the client, and the judge wasn't going to let him go forward, and so the judge said, "You're out. Go find another lawyer." So
criminal or civil? That
was a criminal case, but that's up to the lawyer and the clients. Until it's not, if it ever gets to that point. But if somebody's comfortable with one lawyer representing however many there are, that's up to them.
Or if they want to do it to keep one person under control. I mean, there could come a time where Brian Albert and Brian Higgins have differing interests. That's all I'm saying. Craftastical wants to know, Tom, can they take into consideration that Turtle Boy has done so much good work in the same vein in his past, uncovering corruption, etc.? It's his thing.
Who's they? Well, you can't answer that, can you?
I mean, I guess she's saying the judge.
I think to the extent that it's relevant to if we're talking about a trial. I mean, obviously we have a slap motion being filed. That's the first time I'm kind of excited to learn about it. If it gets by that, then I guess that would 12B6, which is I don't know if that's coming, but there might be from the defense failure to state a claim upon which there can be a recovery. That's 12B6 dismissal motion, and then after that would be a summary judgment, which is there are no, after everything coming out, there are no issues left for a jury to determine, Judge. So we're asking that you toss out these claims as summary judgment.
As a matter of law, right?
So there are three now with the anti-slap. Those are the 3 things that might get something tossed out. Obviously the lawyer shoots for the moon and looks to throw everything out. Sometimes the judge finds that some of the counts should go, none of the counts should go, all the counts should go, but it is civil law. And so the burden is significantly lower than what we're used to at all stages. And so rarely does an entire case get thrown out, but it happens. And I talk about that because that leads us to the trial. So the answer to that question from Craftastical. Sure. Yeah. I mean, to the extent that now learning about the slap stuff too, to the extent that what he does is relevant to facts in the case in the trial, then it could be used in evidence.
John says, if he was bit by a dog and fell, it may not be murder, just a tragic accident. But a body moved and evidence fabricated equals unsolved public interest story. That's a good point. Could that make it petitioning activity? A lot of complex issues here. Sherry says, it seems clear that he was sharing his opinion, not claiming fact, given that he never claimed that he had been in the house to witness what occurred. Thanks, Sherry. And Bridget gifted 5 memberships. Thank you, Bridget. You're awesome. You're awesome and amazing. All right. Well, thank you, Laura, very much for your Venmo and for your comments about the Knicks. I appreciate it. Final thoughts, Tom, before we wrap it up, because, the Stanley Cup playoffs are coming on in about half an hour, and you already had your dinner, but I got to go eat some dinner.
Yes.
Final thoughts. Also, chatters, questions, comments, concerns before we wrap it up.
Final thoughts. I'm hoping for 7 games because the Bruins are not in it. I don't have the stress of having my favorite team in the Stanley, and I get to watch terrific hockey. So I want 7 games with overtime in every single game. So go Vegas because they're down.
My hat. Where's my hat?
I appreciate you inviting me back on. It's nice to see you again.
Thank you.
Thanks to everybody who has encouraged me, suggested things. I did a couple of things that were suggested. One was change the name. The other one was get the light.
The light's good.
There was another one. And I'm sorry George Clooney has decided not to come in here today.
Well, that's what Candace said. Can you bring George Clooney in for us?
Georgie and I are both a couple of old goats. We struggle getting out of bed every morning together. Both of our bones crack as we're getting up. And Georgie is probably asleep on top of the couch right now, and I don't want to wake him up. Eventually he'll come in. There's also 2 other cats that I have to. There's Penny, who's a beautiful tortoise shell, and then there's Liam, who is just a big love. So hopefully they'll be in here. I'm hoping to primarily do interviews and this kind of stuff.
Interviews. So are you going to be streaming with the interview with Brian Camp live?
I don't know. I have to make some calls about the prop with regard to attorney-client relationship.
Music to my soul. I'm not seeing a super chat here unless I covered it earlier. Can you put the question in the chat again? Because it's not in my list of super chat. Oh, here. Sorry. What does Tom think of Karen being convicted of OUI and the use of the retrograde extrapolation analysis? Karen's probation for that is scheduled to end this week, right? It's June. Is it June 17th or 18th that she was acquitted? That was a scandal. They did not charge her originally with the OUI. Her attorneys added that in, And
I was screaming for them to do that. Yes. Because they didn't have that in the first one. And what that did was it gave somebody who needed to convict her of something to convict her of something. The problem, again, yelling at the screen, I don't know if she would have been if those interviews were not given where she talked about that stuff. And moving forward, man, again, it's only my opinion, but I mean that whatever the morning interview, that did not go well.
Oh, the Today Show, the one recently? Right. Like, what does it feel like when you're walking around, and people are all looking at you thinking you got away with murdering your boyfriend?
Yeah, that was a gotcha question, but what do we expect in this day and age? That's what's coming. Okay, so it came, and he asked it in a way where she's walking down the street and seeing all these people who supposedly think she killed. She says, I haven't come into contact with anybody answering that question. And then the other gotcha question, have you looked online? And I was just like, why?
Do you go on the internet?
Why? Why even expose to that?
Why put yourself in that position? I mean, I can see the reason that she went on was because the day before was the day she dropped this explosive lawsuit, with all of Proctor's horrific, heinous text messages between him and Sean Good. And they didn't even talk about that at all. I mean, Alan Jackson tried to, but the hosts didn't want anything to do with that. They wanted the salacious, details. But again, back to this question, the extrapolation analysis that they did was such bullshit. It was like they did a blood draw. They claimed that she killed him around 12:30, 12:45. They do a blood draw subject to a section 12 at like 9 a.m. And then they try and extrapolate it back to the night before. And then the swing was wild because it was a, I don't remember if it was whole blood analysis or serum, whatever it was is not the right blood analysis they need to do on an OUI, as you, I'm sure, know.
My opinion, that was the craziest equation extrapolation I've ever seen. Like, maybe it could have been precluded from even coming in because I wasn't following how they came up with the why. I mean, it was like 0 to 1,000, if I'm not, obviously exaggerating, but that.
Yeah, it was like the swing was, it could have been anywhere between like, 0.12 to 0.29. Like that's how wide the swing was. It never should have come in my opinion.
But they didn't need the extrapolation is what I'm saying because of stuff that was said on interviews.
Because she admitted to having X amount of drinks. I know.
So we have a video of the bar, which showed a lot of different stuff. Some of it upset me. We got a video. We have interviews talking about what and how much. And if they're looking for the evidence.
It was based on her own admissions.
She admitted to driving. She admitted to driving on a public way because you got to prove operation, public way, and under the influence of intoxicating liquor or blood alcohol content of 0.08 or higher. So those elements were all there, in my opinion, for the conviction.
Right. I agree. I mean, I think that's why one of the reasons they edited it in.
I'm glad that they did.
We're smart.
But yeah, I'll take a first offense OUI over a second degree murder.
I agree. All right. I'm going to say goodnight for the evening. Good night, everybody. Make sure your notifications are set. Make sure you're subscribed. Make sure that you still have all your, all the things. Subscribe, notifications set, all that good stuff. Tom, I'll meet you backstage in about a minute so that we can debrief. And so hang out.
Figure out my camera.
Yeah, everyone go sub to Tom's new channel, which is linked below this in the show notes. And are you going to be interviewing Brian Camp live on your show?
It's up to him. Got to talk to him.
Yeah, otherwise you're going to have to get Ethernet. If you're going to do it, you have to. Both of you have to have Ethernet because it's.
I got to get Ethernet because this is making me crazy.
I know it makes me crazy too, but I'm okay with it. I handled it really well. People are saying. Just McGee, first anti-slap in Pennsylvania includes Dog the Bounty Hunter and 10 other plaintiffs against 2 YouTubers at Night Media LLC et al. V. Sang et al. All right, there's the docket number. If you feel like researching anything tonight, Tom.
Wow.
CV 2024-009-083. It's in appeals now. Oh, that's interesting. Thank you very much for your 20. Tom, I feel like Tom likes to research. Research is like, I'd rather stick a fork in my eye than do any research. I hire people that I would, I'm obviously on YouTube now, but I always had associates writing briefs and stuff like that. I have no time for that.
There's a difference between researching, especially now with the brand new AI research software, which is incredible, and writing. I'm not a good writer. I hire somebody to write for me.
All right. I'm going to have a video by Toy play us out, and we are going to go off screen while this one comes on. And I'll see all you guys tomorrow. Make sure your notifications are set. I love you guys. Stay cool, stay kind, stay classy. Don't believe everything you read on the internet, and stay safe out there. Hit the like button, do all the things. I love you, moderators. I could never, ever do this without you. Thanks, Toy, for making this video for me. Hold on. Where is it? There we go.
Welcome to the SS Cupcake Yacht Club. All aboard SS Cupcake, steady vibes on love already. Floating on this don't see so sweet, smooth and clean. I don't know what I mean. We're cruising. Gotta trust. Yeah. Say it loud, make it chatty. Yeah. Galley crew, we I love you. Today saying, oh no, yeah. No. Overruled. Keep it moving. If not, there's a special spot for you. Black Island. Already had a speedy ride for you on the SS ship of fools. Bye-bye. Get it? Hey,